Today, I want to talk to you about my favorite subject, the law. What really is the meaning of that wonderful, demonic, classic, contagious word, the law? Thousands of books have been written about the law. Hundreds of thinkers, philosophers, essayists, poets, politicians, judges, scholars, they've all written lots of books on the law. But what really is the law? And do we really need the law? What about primitive societies that required no laws, but who believed in keeping order? And once you have order and there is no disorder, you have law. It has been said that the law may be an ass, but it need not be asinine. But the law has become asinine, especially if you have a government that is writing these laws. Now, we've been told that we are a government of laws and not a government of men. Frederick Bastiat, a French philosopher, lawyer, political scientist, once said in his classic treatise, The Law, that we rather have a country ruled by law than a country ruled by men. But here is the rub. All laws are made by man. Men in power, women in power, in the Congress, in the Parliament. So really, is the law completely infallible? Or is it subject to a lot of twists and turns and ironing out of the wrinkles? That is a problem that we face in America today and in every other conceivable nation state. When you give the power to make laws to men and women who get elected into office, there is a ready-made menace. There is a ready-made, ready to blow into your face fuse, if you like, because the laws are faulty. Now, there is a school of thought in America, the legal realists, critical legal studies, positive law, legal realism, social jurisprudence. They give it all kinds of tags. But these are laws made by men and women. And these are laws that are interpreted by men and women. And that is the problem because we all make mistakes. So can we aspire to a higher law that does not invite, entertain danger or hazards to everyday living? And that's where we go into natural law. This is the law created by all of nature. This is the law that is given by God, by a supreme deity, by a supreme lawgiver. Does it work? It has worked. We have the Ten Commandments, for example, which are expressed in the American Constitution as the 10 Amendments. But do they work? Has it worked? I have not seen it really work because the Supreme Court of the United States has come up with a theory called the constitutional avoidance theory. That means if a statute seems to be unconstitutional, but it is not ambiguous, then there is no need to consult the Constitution. Really? Then why the devil do we have the Constitution in the first place? Is it there as a powerful, anachronistic, sacred document that we just go and look at it behind vacuum filled or vacuum glass, oxygen control, to look at the original Constitution. Is that what the Constitution is all about? It's valid for a tourist ticket. You pay a fee, you go and have a look at the Constitution. Wow, this is what they wrote and signed for in 1776. Is that what the Constitution is all about? Is it not there for ready reference? Is it not there to cite and quote when things go wrong? Well, that's what they want us to believe, the so-called government. So I believe, ladies and gentlemen, our hope rests with common sense, good reason, powerful justification, and the ability to rationalize. Now, we have what's known as judicial review in America, based on the ubiquitous Marbury versus Madison. That is, when the government makes, or when the Congress makes a law which is seemingly repugnant to the Constitution, then the judges of the Supreme Court can declare that law unconstitutional, i.e., repugnant to the Constitution. So, does judicial review work for every case? Not that I know of. Judicial review of a statute these days is often not disturbed because everything is politics. As Professor Rex Mursky of the Texas School of Law once said, all federal appointments to judgeships have a political patronage attached to it. Some governor who liked a lawyer, and some governor who's got the ear of the president, you just go in there and say, so-and-so is the right candidate for this judgeship. So he or she gets into that position of a judge. Well, during President Reagan's time, there were tons, if not hundreds, of judicial appointments to judgeships, and most of them were Republicans. All of them were Republicans. So we are fond of talking about the rule of law. We are fond of talking about the power of the law, that the law is the handmaiden of justice. And there are all kinds of nice sounding cliches, metaphors used about the rule of law. But what about the role of justice? Why don't they talk about the rule of justice? Why is it they talk about the role of law and then they talk about a court of law? There was a time when someone apparently, I think it was Judge Leonard Hand and Supreme Court Associate Justice Oliver Wendell Holmes, they were supposed to have had lunch and they bid each other goodbye, farewell. And as the judges were separating, they were walking away from each other, Judge Hand called up and said to Judge Holmes, do justice, Judge. And Judge Holmes reportedly said, I cannot do that. I can only apply the law. And there was another time when a New York lawyer apparently told the Justice Holmes that he has come to do justice. And Justice Holmes apparently turned around and said, that we cannot do. This is a court of law. So, and this is Justice Holmes, Oliver Wendell Holmes Jr., who was famous for saying that the law is not what you rummage through law books and textbooks and treatises and what have you. He said the law is that which the courts say it is. Now that is a dramatic statement, a very true statement, because often in our judgments, state courts, municipal courts, federal courts, they apply the law. If the law is wrinkled, they don't iron it out. If the law is contorted, distorted, or wrinkled, they make new law. And that's where common law comes about. Judge-made law. Be very careful of judge-made law because it is made by a person or persons who have a certain philosophy. a certain legal philosophy, which could not always be accurate, which could not always be right on target. Because when you are rendering justice, you are supposed to look at the totality of all the facts. The law should not be a respecter of persons. The law should look at what is right and not what is popular. This is why we in the tribal governments, we have courts of equity. We apply the 19 maxims of equity. We look at the law, we look at the principles of law, we look at case law, we look at common law, we look at everything. If common law, the written law, the law in the textbooks, American jurisprudence is inconsistent with native law, with tribal law, we will not apply it. If it favors tribal law, if it favors the ancient tribal code, if it favors God's law above all, we will apply it. So this is just an introduction, my friends, to want you to be warned and cautioned that when you go into a court of law in America today, whether it's for a traffic infraction or whether it's for a civil or criminal case, in any state or federal court, remember, these are men-made laws. These are judge-made laws. And then they have rules of court that are even more onerous than the substantive law. So we have the rule of law and the law of rules. And if you are not politically correct, if you are advancing a cause that could cause problems to the government, then you're not going to win. It's a crapshoot, a throw of the dice. So we ask you to consider, do you want to go to a court of law, or do you want to approach and file a petition in a court of equity? Tribal courts have been here for many, many years. Tribal courts will give you not an alternate dispute resolution system, but a tribal court will look at the totality of the facts, will look at every nuance, will look at every turn, twist, and time-tested principle of law to see if this will render true justice. Justice really means fairness. Has there been fairness? Do I deserve what I get? Do I get justice for one man, which could affect all the society? Is one man or one woman's rights to be marginalized, to be ignored just because the majority doesn't like it? Or should that one person get justice, even if it's a very unpopular sentence or a decision or a judgment? Shouldn't one person count? Or should we be democratic and say, wait a minute, if I give this man or this woman or this child justice, and if 99% of the people say, no, that was a bad decision, am I going to bend to the demands of the 99%, who may be popularly, politically correct in what they're asking? But in terms of law and justice, that one person is going to be disadvantaged. What would you do? What we do is we look at every person's rights, rights that are antecedent to the United States Constitution. We look at what really happened between the litigant, the complainant, and the defendant or the plaintiff, or whoever, all the parties. We will leave no stone unturned. We have what's known as a very open-ended law of evidence. You know, we don't believe in immaterial, irrelevant, prejudicial justice. or rules of evidence. If someone says, well, my past doesn't count, I have raped, I have plundered, I have stolen, I have killed, but my rap sheet is irrelevant. And right now, he's facing a murder charge. Why shouldn't we look at his past record? What kind of law is that? So, it's got nothing to do with being liberal, it's got nothing to do with being conservative, it's got everything to do with what's right. It's got nothing to do with what's popular. So, therein ends our first lesson in what the law is supposed to be. We'll continue discussing this concept, this nebulous concept called the law. And be careful, my friends. There is many a flaw in the law. And sometimes, oftentimes, I wonder if I should be a flawyer, not just a lawyer, who became a federal tribal judge. Thank you very much. Today, according to my calendar in Hong Kong, is Thursday, I believe it's February the 18th, Chinese New Year. So thank you for your time. Thank you for your... Thank you.